Good afternoon. Welcome to our webinar. While we're waiting for everyone to be admitted into the event, some housekeeping from me. We will be recording the webinar and we will circulate the recording to those who would like a copy afterwards. For those of you who are familiar with Zoom conferencing, you'll know that if you hold your cursor over the screen, you will see the controls bar, which lets you choose either questions and answers or chat. For this session, we would like to ask you to use the Q&A icon, which allows you to type your question in without anyone else seeing it. We hope to have lots of questions and we'll try to answer as many of them as we can in the session, but we'd be happy to follow up with answers later if we can't get through all the questions. So I'd encourage you to leave your name and your details along with your question if you'd like to do so. I won't be identifying anyone of the questioners by name during the session. So I think we have most of our participants in now, so we will get started formally. So welcome to everyone and to our Brodie's webinar this afternoon. I'm Joyce Cullen, one of the Brodie's commercial litigation partners, and I'm joined by my colleagues Jane Rattray in Aberdeen and Ross Mitchell in Edinburgh. Both of them are experienced associates in our commercial dispute resolution team. My role today is simply to introduce the webinar and to manage the Q&A sessions, which we will have at the end of each of our two presentations. We hope that this will be an interactive session with time for our presenters to answer lots of questions which you've posed during their presentation. So please do use the Q&A buttons to ask a question as we go along, and they'll be picked up by me and I will put them to the presenters at the end. The subject of our webinar today, as you know, is dispute resolution during COVID-19, and we'll be focusing particularly on two methods of resolving disputes, mediation and arbitration, which are of course always outside the court setting, so alternative methods of dispute resolution. As many of you will be aware, our civil courts are currently available for urgent business, and there are now some virtual hearings taking place by phone and video conferencing, where no witnesses are involved. However, it's likely to be a while before they are anything like business as usual in the civil courts, and we do, I'm afraid, anticipate a backlog. In contrast, many legal firms are able to offer a full service on a remote working basis, and at Brodie's all our litigation lawyers and most of our colleagues providing litigation support are operating very well on a remote basis. So while the court system is somewhat stalled, we have been talking to clients about alternative dispute resolution, looking to see whether there will be a solution for both sides that would agree to that, even if they haven't thought about ADR clauses in their contracts at the time they entered into them. There's, of course, a whole range of options for ADR to avoid delay in waiting for the courts to determine a dispute, and we know that many clients are already negotiating with customers and suppliers to try to find a solution rather than litigating in court. And as no doubt some of you have read in the press, former UK Supreme Court Justice Lord Sumption has expressed the view that we should be negotiating rather than relying on the courts in future. But if negotiations become difficult or they break down, we think that both mediation and arbitration are going to be particularly useful in the coming months to secure a swift resolution. Mediation is, of course, an example of a negotiated resolution process, which the parties would have to find an agreement, whereas arbitration provides a relatively speedy route for a decision to be taken by a third party, which is binding on the parties in dispute. What we will cover, you will see on the slide, the various issues we propose to cover. We'll be hearing from Jane about one example of a successful mediation, which she did remotely using Zoom, and then from Ross about the flexibility offered in an arbitration process, conducting it online with all the issues and difficulties which might arise and how we can find some solutions for that. So he'll be looking at how evidence is given by witnesses, documents can be accessed by everyone involved, and all the other practical things that may come up. So I'm going to hand over to Jane now, and please remember to be thinking about questions as we go. Jane.
Thanks, Joyce. Good afternoon, everyone, and welcome to our seminar. Thank you for coming along. For those of you who don't know me, my name is Jane Rattray. I'm an associate in the Business Disputes and Asset Recovery team at Brodie's. On a day-to-day basis, I deal with a variety of different commercial and property disputes. As I'm based in Brodie's Aberdeen office, a lot of these disputes involve oil and gas contracts, which commonly include an arbitration clause, which Ross is going to come on to discuss in a bit more detail later on. And these types of contracts are often governed by English law and or are the subject of the jurisdiction of the English courts. Mediation is far more strongly incentivised by the English court system than in Scotland, so a lot of these types of disputes will be resolved by way of mediation. Firstly, having a look at what mediation is. Most of you will be familiar with this already, but for anyone who is new to mediation, it's a process whereby a neutral, independent mediator assists parties to work out their own solution to a dispute, rather than a decision being imposed upon them by a third party, such as a court or an arbitrator. Usually mediations would be held face-to-face. The parties, their legal teams, and the mediator will all attend at the same venue and set up in different rooms. The mediator will then speak to both teams and, if it's appropriate to do so, bring the teams or sometimes just the parties' legal representatives together to have a joint session. Moving on to my next slide, which is about remote mediation. So in principle, there's no reason why mediations can't be held face-to-face. Before lockdown, remote mediations were held by commercial clients, particularly we saw in international disputes where time and cost of the mediation were concerns for the clients. Most recently, Joyce mentioned this earlier, I was involved in a remote mediation in a Bristol High Court case where a party based in Bristol sued my client who was based in Aberdeen. There were significant cost savings in the mediation being held remotely, so both parties agreed to proceed with remote mediation on that basis. I'll come on to discuss my experience of remote mediation in a bit more detail later on, but firstly let's have a look at how remote mediation works. So remote mediation can be carried out using any video conferencing platform, including apps such as Microsoft Teams and Zoom. Most of you will probably have become familiar with these types of apps in the last 6 weeks or so. Providing that parties have a reliable internet connection, a variety of different devices can be used to participate in a remote mediation. So you can use your desktop computer, laptop, tablet, or a smartphone. A video connection is preferable for all participants, but equally it is workable to mix and match video with teleconferencing. You might have an elderly client who's not comfortable using modern technology, but this doesn't necessarily have to prevent a remote mediation from going ahead. There could be a simple workaround. For example, the solicitors could use video conferencing and communicate with their client by just putting them on speakerphone on the telephone so that they can hear what's happening. Next, we're going to have a wee look at what preparation is required for mediation. So prior to the meeting, all parties will have to download the software for the video conferencing platform. Both Zoom and Microsoft Teams are free, so parties don't need to purchase the download. It is recommended that in advance of the mediation, each party test their connection to the video conferencing platform. Most video conferencing platforms will have a connection test function on their website that allows you to do so. The mediator will need to be provided with email addresses for every person who is attending at the mediation so that they can send out invites to join the remote mediation. The mediator will send an email out to the participants which has a link to the meeting, and all you need to do to join the meeting is to click on the link and follow the instructions. In advance of the mediation, the mediator will also arrange a test meeting with each party to ensure that the technology is working and to answer any questions or issues that a participant might have. There is, of course, still the risk that the technology fails on the day. It may be that that's a brief issue that can be resolved and you can continue with the mediation. One option that has been suggested by mediators is for parties to agree in advance of the mediation that if after the remote mediation started, either party is feeling uncomfortable continuing with the remote mediation, then the mediation can be adjourned until parties are comfortable with the technology or until a face-to-face mediation can be carried out. Clearly, this is going to have cost implications and it's going to cause delay in reaching a resolution. So use of technology is a factor that needs to be carefully considered before proceeding with a remote mediation. Looking next at what is the process on the day of the mediation. So each party will have received an email from the mediator with the meeting link. At the appointed time, parties click on the link, which brings them into a virtual waiting room. And what parties will see is the case details on the screen. Nothing else will happen until the mediator then starts the mediation. Parties will not see each other face to face at this point or throughout the mediation unless they agree to do so. It's also important to note that the mediation will not be recorded because a lot of these types of apps do have recording facilities, and that's something that should be included in the mediator's terms. Once the mediation is started, the mediators will invite parties into pre-assigned breakout rooms. The mediator will explain to each party, to the parties in each breakout room, how the process is going to work. Much of this explanation is going to be the same as if the mediation was being carried out face-to-face. The breakout rooms are private and they can only be accessed by parties given permission by the mediator. Each party should be able to see by video conferencing and or audio who's in the breakout room at any given time, so you know who you're going to be speaking to. If the parties are not ready to speak to the mediator, then the parties can ask the mediator to come back later and can then later contact the mediator using the Ask for Help tab. If parties do have any concerns about privacy, then they can mute or they can log out of the virtual breakout room at any time, and they can then have a private telephone conversation. Or you could be communicating by email or WhatsApp messages or some other method. Some of you might have heard of Zoom bombing. This is what happens when an uninvited party accesses a Zoom conversation. The examples in the media of this have involved use of offensive language or sharing offensive images on your screen. This can be avoided by the mediator making the video conferencing meeting private and password protected, requiring that access to the meeting is via a waiting room, and also changing the settings so that the host, who would be the mediator, has control over when parties can share their screens. As usual, at the private opening sessions in the breakout rooms, the mediator will discuss with the parties whether a joint session is wanted by the parties, and if so, the mediator will bring the parties from the breakout rooms into a virtual joint session. The mediation will then proceed as it would in person. Just as in a face-to-face plenary session, a solicitor or party can say that they would like to discuss matters privately, and the mediator could then allocate those parties to a separate breakout room to have a private discussion. When the plenary session is finished, the mediator will put the parties back into the virtual breakout rooms. Parties can share documents by sharing their screen. There's also other methods such as email or Dropbox. There's also a facility on the Zoom app where you can use an electronic whiteboard if parties wanted to illustrate their point. Clients can also plug in an iPad and use it to draw and write on it and can share their screen. One problem that might be encountered if discussions were to get a bit heated is that a party could simply log off the virtual mediation, and that's going to be much easier for someone to do than it would be to get up and walk out of a room or a building, as you would have to do at a face-to-face mediation. It's not exceptional for a mediator to have to try and stop a party from leaving a mediation. The mediator has all of the parties' email addresses and telephone numbers, so if this was to happen, then in a similar way as they would at a face-to-face mediation, the mediator would contact any party who's tried to leave the mediation and attempt them to try and cooperate. All being well, hopefully you would reach a settlement on the day of your mediation. So what happens if a settlement is reached? Drafts of the settlement agreement could be circulated and finalised by email, and this is probably how you would find it being done at face-to-face mediation anyway. For the Bristol mediation that I was involved in, we were in the office. This was pre-lockdown, so we were in the office with clients, and we just printed and signed a copy of the consent order and then scanned it to the claimant's lawyers, and the claimant then signed the scanned copy. Bristol High Court were happy to proceed on the basis that both parties had not principally signed the consent order. At the moment, you're not going to be in the office with clients, so if parties both have printers and are able to scan or take a photograph of the agreement, then it may be possible to sign the settlement agreement the same day and counterpart that way. While clearly it would be better for the settlement agreement to be signed on the same day, if this is not possible, then agreement could be reached over the terms of the settlement agreement, and then other arrangements could be put in place for execution of the settlement agreement at a later stage. Parties can also consider the use of electronic signatures. Under both Scots and English law, the majority of day-to-day contracts can be created electronically. However, it is important to note that there are different methods of electronic signing which offer different levels of assurance that the document was authenticated by the person purporting to sign it. Electronic signatures is quite a vast topic in itself, so I'm not going to go into that in any detail today, save as to say that it is an option to consider. Another point that I wanted to highlight is that it's common for settlement agreements in Scotland, for example, if you were reaching a settlement pre-court action, to be registered in the books of council and session. The benefit of doing this is that if a party defaults on their obligations under the settlement agreement, the other party can take steps to recover the sums due without having to actually go to the bother of raising a court action. Most of you will be aware that Registrars of Scotland have launched a digital registration system since we've gone into lockdown, but as far as I'm aware, they are still presently requiring a wet signature on any documents to be registered in the books of council and session. So if that's something that you're looking to achieve, it's worth bearing in mind that an electronic signature is not going to do the trick for you there. So moving on to my next slide, which is the big question, does remote mediation work? Certainly in my experience, remote mediation offers an effective method for resolving disputes. I mentioned earlier that I was most recently involved in a remote mediation, which was part of a Bristol High Court case. That dispute was about the sale of a high-value villa in Florida. My clients lived in Aberdeen, the other party lived in Bristol, and it was agreed between the parties for the mediation to be held remotely with the claimants. They had a barrister and a lawyer, and the mediator were all down in Bristol at the claimant solicitor's offices, and for our clients and myself to be in our offices in Aberdeen. This saved our clients significant costs in travelling to Bristol. They also didn't have to pay for my time and cost in travelling to Bristol, and there were savings as we didn't have to hire rooms in which to hold the mediation. Overall, the mediation lasted for about 10 hours, but we did successfully reach a conclusion and we signed the consent order the same day. And that was a very good result for our clients because if the case had gone to a full hearing of evidence, there would have been a number of parties who would have had to travel to Bristol, including our clients and potentially some parties from the US. So it could have been a hugely expensive exercise for our clients. Maybe that some solicitors and their clients are sceptical about remote mediations, but my experience is that it's a good alternative to face-to-face mediation, and it doesn't diminish the chances of reaching a resolution. As Joyce was saying, litigation has hit a pause in the UK during lockdown, and I certainly would encourage parties to consider remote mediation as an effective alternative method of resolving disputes during this period and also beyond. That's pretty much everything that I was planning to cover today. So I think I'll hand you back to Joyce, who will let us know if we've had any questions.
Yes, thanks. That's very helpful, Jane. There have been, a couple of questions actually, which relate to some of the points you were making. One, I think, particular in relation to security, is a very interesting question being raised about documents. I mean, you've explained obviously that so far as people coming into the mediation are concerned, that's under the control of the mediator. If you're sharing documents, one of the questions is when you're sharing a document with a screenshot, you're sending a document, somebody could take a copy of it and keep it. And whereas in a mediation, you might be willing to hand over a document to show it to someone on the assumption you would get it back there and then, what if they take a screenshot? What are the risks there that it might come out, at a later stage?
Yes, I mean, that is technically a possibility. What we should bear in mind is that in advance of arranging the mediation, parties will all have signed some sort of agreement which will make what happens at the mediation confidential. So they will have confidentiality obligations, and that's certainly something that you could put into an agreement that was reached before the mediation to try and protect your client's position was that to happen. As far as I'm aware, and I'm not an IT expert, I don't think there's an IT way of preventing that from happening during the course of the mediation. So you would be best to try and protect your position by entering into a prior arrangement.
And I suppose in the same way as all mediations to some extent are based on trust. If you're signing up, you're promising not to do something. I suppose you could actually make an obligation not to copy documents unless permission's been given to them. And then it's not to say people are not going to be dishonest from time to time, but at least they would be realizing they were in breach of their obligations, and I suppose that's the best you can do in a sense. Another question that's come up, Jane, is about cost. I mean, I think you mentioned at the beginning that obviously the travel costs are saved. Is there any difference in terms of how much it's likely to cost? Does the mediation itself tend to take longer or less time, or are there other things that might be thought about in terms of the actual cost of mediator, for example?
Well, you'd be looking at, there's obviously different elements of the cost of your mediation. So you'd have your preparation costs, which would largely be the same, other than a few additional things that you would have to do in terms of testing the connection. But they're not time-consuming matters. So I would say that the preparation cost would be roughly the same. You can never really tell how long any court hearing or mediation or meeting is going to take. But I have discussed it with a couple of mediators, and their experience tends to be that they're roughly taking the same amount of time, if not slightly shorter, to resolve mediations on the day, because I think people get a little bit fed up being sat at their computer screens all day, and there's less human interaction there. So it's encouraging people to move towards reaching a settlement earlier in the day is the feedback that I've had.
Yeah.
I would have
Okay.
thought,
Sorry, on you go.
I would have thought the cost of on the day of the mediation would be roughly the same. Your savings are going to be your travel costs, and any outlays for travel and any outlays for room costs that you wouldn't have to pay.
Sure. Okay, well, shall we take one more question just now on this? We will have time at the end after off the session 2 for questions that will come back to Jane too. But one, I think, interesting or question is that do we know if people are actually using mediations during lockdown at present? It sounds, Jane, as if you have been speaking to mediators about their own experiences. Are they going ahead in the last 6 weeks or whatever?
Yes, they are. I have spoken to quite a few mediators about this. As I said during my presentation, mediation is used more frequently in English because in England, because the English courts incentivise use of it more so than the Scottish courts. Most of the reports that I've heard about mediation have been in England, but as far as I'm aware, there have been Scottish mediations also going on during the lockdown period. So it is being used, and parties are reaching successful conclusions on sort of disputes during lockdown. So it is effective.
Great. And one final question just for the moment then is, I know we're all, well, speaking personally in my generation, are learning to use the technology that's available. And I think actually pretty successfully up till now. What's your experience of mediators and obviously arbitrators too when we come to Ross, of how well trained they are? Mediators are not all, of course, of a particular generation, but they do tend to be at the more senior end of whichever profession they're in. Are they coping or are they making a mess of it?
I think they're coping very well. There wasn't that much out there on the internet about remote mediations prior to lockdown. It's something that's really been amped up. So I think what's happened is that a lot of mediators have had to get up to speed with this quite quickly to ensure that they can continue offering their services. But certainly for anyone who has a particular interest in it, there's many mediators who are offering to do trial sessions to show you how it works.
Yeah.
And the ones that I've attended have operated it very well. So I don't have any complaints on that front.
Good stuff. Okay, well, time is moving on. So I think we'll move on now to Ross, who is going to, I'm sure, cover some of the same sort of issues that have come up in Jane's presentation, but focusing on arbitration, which of course, as Ross will explain, is a judge making a decision and tends to be a much more formal process than mediation. So over to Ross, thanks.
Thank you, Joyce, and thank you, Jane, as well. And also thank you to everyone for logging on this afternoon. For those of you that don't know me, I'm also an associate based in the Business Disputes and Asset Recovery team, though I work normally out of the Edinburgh office. So what I'm going to discuss briefly this afternoon is remote arbitration. And what I'm not going to do is give everyone a back to basics overview of arbitration, but instead look at some of the existing rules that are in place that will allow for arbitrations to be done entirely remotely. And so the existing rules that are set out for arbitration are known as the Seoul Protocol. And the Seoul Protocol are a set of rules for conducting arbitrations entirely remotely. And they were designed and devised by the Seoul International Dispute Resolution Centre. And they're a set of rules that practitioners and clients and companies involved in litigation are going to become a lot more familiar with as time goes on. And actually, it's worth mentioning that despite the fact it's clearly of particular interest now, the protocol was actually devised in November of 2018. And that was because it was devised in recognition of the fact that even from 2018 and earlier, international arbitrations were becoming increasingly globalized, whereas at the same time, underlying video conferencing technology is becoming better, more powerful, and sophisticated. So this is something that has been going on for several years now, but is likely to become more commonplace. And so I think, as with other changes, such as, for example, an increase in working from home, what COVID-19 has really done in this sphere is actually just accelerated a trend that probably would have been happening slowly in the background anyway. And thankfully, we've seen quite a quick response from the types of bodies that organise and oversee international arbitration. So the main one I'm going to look at is International Court of Arbitration, which is part of the International Chamber of Commerce, and what they've done in encouraging and facilitating remote arbitrations. So this is the body which sets out the rules and manages most international arbitrations. And on the 9th of April this year, it published quite a detailed guidance note which made it clear to existing and future arbitration tribunals that if remote hearings can be adequately implemented, then they should be, because ultimately there's going to be less disruption to businesses throughout this time and at the end of it, because they still need disputes to be resolved quickly in order to move on and get on with business. And so to that end, they've pointed out that existing arbitration tribunals can take measures already, including techniques such as involving disputes on the basis of documents only, with no evidential hearing, or alternatively using either audio conferencing or video conferencing for hearings where that's possible and appropriate. But before we move on to the kind of details of actual video arbitration, it's worth mentioning some of the other steps that the ICC have pointed out tribunals can take now, which will reduce the need for procedural delays and mean that the remote element of the arbitration, when it occurs, can happen as quickly as possible. So firstly, all documents can now be lodged and transmitted electronically. The Secretariat of that court now expressly requires that any new requests for arbitrations must only be submitted electronically, which is a big relief to practitioners who are familiar with the volumes of folders and paperwork that need to be produced in commencing an arbitration. Equally, any documents that require to be signed, such as the terms of reference, can now be done entirely electronically. And actually, these are quite good examples of changes that I can't see why we would ever want to go back to the old method. Even when we are at a point of conducting arbitrations in person, I can't see why we would want to go back to producing volumes of paper and insisting on signed terms of references. But beyond that, there are things that procedurally parties can do now, and the court are encouraging arbitrators and tribunal panels to do now. So, for example, parties can establish an agreed chronology of facts in the case, joint lists of issues, etc., in document format, so that when it comes to giving witness evidence, it's as focused as it needs to be, so as little time needs to be spent on the remote video element. Tribunals should actually identify any issues that they think can be resolved without witnesses or experts at all. So, for example, on the basis of written questions that are submitted to the opposite party, and then written answers can come back. Now, that's not going to be appropriate in every situation. Sometimes there has to be that element of actual examination. Arbitrations are also going to have more regular procedural conferences throughout the arbitration. So, on the face of it, that's going to mean more time spent communicating with the arbitrator, etc. But the purpose of these conferences are going to be to regularly assess where the case is, what are the most relevant issues at this point, and is there anything that can be done at that point to focus the dispute more narrowly. And actually, that's an approach that the Commercial Court in Scotland takes, for example, regular procedural conferences. And generally, that is an effective method at resolving and narrowing the scope when it comes to actual evidence being heard. And finally, tribunals are being encouraged to resolve the issues in dispute in stages if they can. So that means rendering one or more partial awards, where doing so is likely to result in a more efficient resolution of the case. But turning now to what the Seoul Protocol itself actually is, and what it sets out, and why we're talking about it today. So what it is a ready-made set of rules that it's quite likely that arbitration tribunals are going to begin to adopt. And what I will say, and as it will become clear as we look through the rules in a moment, is that they've clearly been designed in mind that witnesses will be in the same venue as their legal team, which is obviously not possible at the moment. So what they are is a good default set of rules that will be adopted as a template in their current climate. But it seems fairly likely to me that a revised version of these rules are going to come out soon, and even when they are implemented in the meantime, they will need to be tweaked by parties and by the arbitration tribunal. So turning then to some of the preparatory steps that need to be carried out for the remote arbitration to work. the Seoul Protocol sets out that the practical side of arranging a remote arbitration would normally fall on the party that makes the request for the arbitration to be conducted remotely. So the rules are basically saying, look, if you want to do this remotely, you've got to go to the additional trouble of making sure that works. So not, for example, the claimant, as you would default expect to be the case in an arbitration. So what do we mean by preparatory steps? Things like ensuring that suitable booking, ensuring that suitable video conferencing facilities are booked in advance and shared, etc. What I think is quite likely, though, is that now that remote arbitration is going to be imposed on the tribunal, imposed by the tribunal rather, they're going to more proactively tell parties which video conferencing software is going to be used, etc., and lay the groundwork rather than imposing that as a burden on the party that wants to conduct the arbitration remotely. Interestingly, the Seoul Protocol, one of the very prescriptive rules is that a seating plan needs to be agreed and shared in advance. That's obviously so that you could know who it was that you were speaking to, but obviously was envisaged in a pre-COVID world where parties were going to be in the same room as their legal team, and that is obviously quite likely to be waived as a requirement in the shorter term. But if we start to think about how this might continue to play in the sort of medium to longer term, and as the world does begin to return to what people are terming the new normal, you can see a situation whereby parties can be in the same room as their legal team, but not necessarily able to travel internationally to take part in an international arbitration. So things like seating plans might again become relevant under the protocol and probably will stay in place for that reason. A key crucial preparatory step if you're wanting to conduct a remote arbitration is going to be on documents and making sure that any documents which are on the record, which witnesses are going to be referred to, must be very clearly identified, paginated, and made available to the witnesses. And that's done fairly easily. It can be done by, for example, agreeing a joint document repository for that purpose, so software like Dropbox, etc. And the concept of shared document repositories is something that lawyers are already very used to dealing with and can implement immediately. And finally, as a preparatory step, the facilities need to be thoroughly tested prior to the arbitration, and the rules are very clear on that. And so previously, the preparatory steps in setting up the technology, etc., is something really that you would expect the tribunal and the lawyers and their technical team to be involved with, and witnesses and parties, etc., would kind of be kept out of that. It would happen in the background. Now that witnesses and parties are going to be dialing in directly, that's something that everyone is going to be involved with for this to work. And the general rule under the protocol is that you have to have 2 tests of the technology before it works. So once well in advance of the commencement of the hearing, and then once immediately prior to the video conferencing itself. So turning then to the issue of the examination of witnesses in remote arbitration. What I will just add as a general observation is that my own experience in having observed evidence being taken remotely is that it is a far slower process than evidence being taken in person. And that's for a few reasons. There is just an inevitable lag in communications being transmitted that can sort of add up over the course of evidence being taken over several hours. And it can be harder to refer witnesses to documents quite as quickly as you would like if you both had, for example, an identical folder in front of you and you were turning to tabs. Generally, I would also say it's slightly less effective from the perspective of the person taking the evidence. It's much harder to read a person's reaction and their body language when they're giving an answer, which is often quite key in determining your own follow-up question, your follow-up approach generally, or how you phrase and approach a witness in terms of your own demeanour. That being said, it is something that's perfectly possible and actually has been occurring within the Scottish court system for many years now. So provided the underlying technology works well, which as we can see this afternoon, it does do, it's something that can be done quite effectively. What the Seoul Protocol does, though, is it sets out several basic requirements for the taking of evidence remotely. So the first requirement for the examination of witnesses is that a reasonable part of the interior of the room that they are in has to be shown on screen, as well as retaining sufficient proximity to clearly depict the witness. I think that's quite an interesting requirement, particularly given platforms like Teams give you the option to blur out your background. Zoom, I could have blurred out my background, and there are good reasons for people wanting to do that. Most of us are now working from home and don't necessarily want that level of intrusion into our home or a private space, particularly when it's a contentious litigation. So I think that is a requirement that parties should be aware of as in the default rules, but are quite likely to want to waive and waive that requirement to display the witness's room quite early on. Clearly, another practical aim when giving evidence is for there to be as few distractions as possible and to kind of really replicate that very neutral tribunal setting. So the rules say that means a witness should give their evidence at an empty desk. Another interesting option given in the rules is a lectern. I don't think many of us will have a lectern in our homes. I certainly don't. But again, if we're thinking about how these rules might stay in place over the medium term, that's maybe something that you can see being in place if you are giving evidence from a lawyer's office, in the context that international travel remains not possible, practical or economical, but domestic social distancing is relaxed. Some witnesses prefer to give evidence standing up, and so it might be that evidence is given stood up in front of a lectern in the future under these protocols. And finally, if possible, parties are encouraged to use a separate display screen or window for the display of documents. And that's really just so that the witness can fully see the examiner at the same time as looking at what can be quite detailed documents, whether they're plans or contractual documents, whatever. Again, from my experience, where evidence is given remotely, the main thing that tends to fall apart or take longer is the issue referring to documents, because it's just not quite as easy as being in person. So if there is the possibility of dual screening for documents and then the video element of the evidence, that'll be hugely helpful. So just turning to some other aspects generally of remote arbitration that people often think about and ask about. The first issue is observers. When a witness is being examined, the only person that should be on the call other than themselves are their legal advisors, if they need an interpreter or a paralegal to assist with documents, etc. The legal representatives from the other side, examiner, etc. And the reason for that is obvious. A big advantage of arbitration is the privacy of it when compared to open court proceedings. And partly to ensure that the correct person is on the call, parties are required to give the identity and prove the identity of every individual in the room in advance. And it might be that the tribunal takes steps to verify that by, for example, asking for a copy of their passport or their identification card, just so that you can be sure that actually the person that's giving that evidence is exactly who they say they are. And as Jane and Joyce talked about earlier, a concern that's been discussed in the media generally is this one of Zoom bombing, where unwanted participants can join private meetings or enter Zoom calls for whatever reason. And just to reiterate the point that Jane made in reference to remote mediation, that can be addressed by ensuring that you're using a secure platform to begin with, but then also making sure that your meetings are password protected when they begin. And the Seoul Protocol tries to take that step further and sets out rules on privacy during remote arbitration. So for example, a party is not entitled by default to take video recordings unless there has been advance leave given by the tribunal. You can actually see some circumstances where the tribunal might think, we want a recording of this witness's evidence so we can analyse it in more detail later on, in the same way that a court would have a transcript of witness's evidence. If that is to occur, all parties are to be made of it well in advance, and videos must be shared with all parties close to the conclusion of the arbitration. Finally, we're also all quite familiar with the frustrating scenario of not being able to see or hear someone properly during video conferencing. thankfully that generally does seem to be occurring less and less as people's internet speeds are getting better, and the video platform technology is getting a lot better as well. But really, it's the last thing that you would want to be interrupting an arbitration. And so the protocol sets out quite a detailed set of audio and video technical requirements that I'm not going to pretend to understand the detail of. But what it does ultimately mean is that if you don't meet those technical requirements, the tribunal can call a halt to the arbitration. So it is worth having either your own technical team look at the capabilities in advance, or alternatively, your lawyer's IT team will have the technical capabilities to check that you meet those standards from the outset. And what I'll just add is that the protocol is actually silent on the exact platform to be used, whether it's Zoom, Teams, etc. So there's scope for discussion on which one parties in the tribunal would prefer. So overall, the Seoul Protocol is a good comprehensive starting point for remote arbitrations. It sets out the framework for how they are to be conducted. And I hope that this has given everyone an idea of how a remote arbitration can be conducted in practice, how it will work. But obviously each particular arbitration is going to require its own tweaks to those rules and the default model, which is a good thing because it means that there can be a degree of flexibility for each case. And that concludes my element, Joyce.
All right,
I don't know if there's any questions coming in.
There are lots of questions coming in, harder and harder, I'm afraid.
Great.
Well, we'll direct the first ones in, I think, to you, Ross, particularly in relation to, I think, giving evidence, which obviously would relate to the arbitration process rather than to mediations. But not being too cynical, as one of our questioners has said, and there are quite a few who have asked questions that are a bit around this subject. Yes, fine, you can confirm that only the people are in the room that you say are in the room. But in a situation where only one person is in the room, in other words, the witness giving evidence without their lawyers there to oversee what's going on and to make sure that everything is done as it should be, what if someone else is in the room mouthing the answers, coaching them, saying, stop here, whatever it would be? Is that an issue which you think will come up, or do you think we are to be less cynical?
I'm sure it will. I'm sure it has, or will inevitably occur. But as with the issue of privacy and recording videos, parties are being expected to sign up to agreements in advance that they would be in breach of if they were to do something like that. And so what the rules will require is parties to sign up to an agreement, and it's made clear to them they'd be in breach if they were to do something like that. And I think what we need to bear in mind is, of course, there are risks that things like that can happen anyway. There's always a risk that a party has been coached before they give their evidence, but what we rely on are the professional, or even in court. You can't entirely rule out that somebody has not been passed something in court, for example. So it's a risk that exists whether we're doing this remotely or not. And so to an extent, you're relying upon good faith of that party, you're relying on the agreement that they are bound to and being in breach of, but also you are relying on the professional obligations that their own advisors owe to you and the tribunal as well to ensure that that's not occurring.
Yeah, and the lawyers themselves. I mean, it's something which, when you're dealing with litigation, in the preparations, we're all being very careful with clients generally to explain to them, they mustn't share their evidence in advance, etc. And I think we would just have to become a little bit more pointed in that advice to make sure that everybody understood exactly what their obligations were. I'm sure that's right. A couple of questions come up with a sort of theme of, do we think this will continue? And a very specific question on that is, in the light of what's happened up to now in the pandemic, are we aware of any new contracts being entered into with dispute clauses that prescribe only remote hearings? So in other words, people actually entering into contracts. I suppose we really need a commercial contracts colleague here to talk about that. But I don't know if either of you are aware of new contracts being entered into on that front.
No, so I'm not aware of new contracts.
No, I think, to be fair, it's maybe something we could come back to, because I suspect, because we are all court dispute resolution lawyers, we tend to see the problems once they arise. I think what we have been seeing is people amending their contracts that they have already entered into in the light of the pandemic, because if there isn't an alternative dispute resolution clause in, then they're finding it's a sensible thing to do, and will agree to that, although it does take two to tango, of course. But it will be very interesting to see whether our commercial contracts lawyers, colleagues, come back and say, actually, this is something we'll write in.
Yeah. And I think probably the other thing that I would emphasize on that front, Joyce, is most existing contracts that have an arbitration clause will just prescribe that arbitration is to proceed under, whatever rule, whether it's the ICC rules, the Scottish arbitration rules. But then those rules in of themselves subsequently allow for remote arbitration. So existing contracts that just have your general arbitration clauses will now be able to proceed by way of remote arbitration.
Yeah, and I don't know, I suppose this is a more general question to both in relation to mediations and arbitration. Do we think that clients will choose to have remote hearings of whatever sort or mediations in preference to being able to meet up? I think maybe Jane, first of all, do you think that's going to continue with mediations?
Yes, I do think it'll continue. I think mainly from a cost saving perspective, clients will want to try and minimise costs. And now that mediators and people have been forced to become familiar with these types of procedures, they should work equally as well as face-to-face mediations would. So I do think it's something that we'll see going forward being used more frequently than it is now.
And Ross, so far as arbitrations are concerned, I think it was very interesting what you were saying earlier about the flexibility in that, we could do a set of rules now which will apply on the basis that everyone has to be in their own room, but that could be modified. And I suppose looking ahead, that might be something that would be seen as quite helpful.
Yeah, absolutely. And I think probably I'd make a similar point to Jane. There are certain elements that introducing remote elements generally to arbitration that are going to stay. So electronic transmission of documents, etc. And I think a lot of people will, by default, want to engage in video conferencing because there'll be a reluctance to travel, etc. But that being said, I think there will still always be a place for witness evidence being taken in person in certain cases. Whether that's because counsel or the parties feel there's a real benefit to be gained from having this witness be examined in person if they think they're going to be particularly tough, or if there is a requirement to take through plans or very technical aspects that just has to be done with almost reference to a presentation. I think there will always be a desire to do certain elements in person.
Yeah, I think a linked question and point about that, I suppose, has come from a couple of questions we have about the relationship between the client and the lawyers and the experts that you would normally be able to have in that chat outside court or even in court if necessary. And do we think that the fact that you're dealing with a hearing or an arbitration, particularly remotely, is going to cause particular difficulties? I suppose the equivalent, as we would say, of tugging counsel's gown. If we're in court, how do you communicate with your lawyer that you don't want to do something, or that you've got additional information you'd like to hand over? Is that something that you can foresee would be sorted out in due course? Maybe Ross first.
Yeah, I'm going to go first. I think that clients and parties who want to do that will prefer this to having to do it in court or in arbitration. So the way that we've seen it working, for example, at the moment where we are acting for clients virtually in court hearings at the moment, is that there'll be the one audio or visual channel with the court where you're making representations to the judge, but separately you'll have another platform where you can communicate directly with other lawyers in the team, and the clients can communicate directly. So you have those two channels of communication. And I think for clients and parties involved in litigations, they'll prefer that because the message stays on counsel's screen, etc. And for those of us that are familiar with having tugged on counsel's gowns, it's going to be harder for them to ignore you and go, no, I need to listen to this bit, or they'll lose the yellow notes that you've handed them. So I think it will create an easier line of communication between parties and their legal advisors in the context of a hearing.
Yeah. And Jane, as far as the communication with your own client, if you like, within the context of a mediation, I think you talked about rooms being set up for different purposes by the mediator. Is that something that you could foresee would happen in a mediation, or is that happening already?
Yeah, so you would be in your own virtual breakout rooms, but these rooms are confidential and you'll be able to see who's in the rooms, and you can mute them at any time if you wanted to have a separate conversation with someone, say by way of telephone or something like that. Or if you had a client who was really concerned that the room that you're in wasn't private, then you could log out of that altogether and have a separate video call or email exchange or WhatsApp or telephone or whatever it is that you want to do. In terms of when the mediation is ongoing, if you are in a joint session, it's probably less of an issue, because similarly to in a face-to-face mediation, if you want to have a private conversation with your client, then you can sort of ask to leave the joint session for that purpose. So the mediator can take you out of the virtual joint session, put you back into your separate room, and then you can ask to come back in when you're ready.
Yeah, I can foresee it. It's a question I've asked myself of a mediator recently, as to, how do you replicate the chance meeting on the way to the loo with the lawyer on the other side? It just gives you that little opportunity to have a chat that you wouldn't otherwise want to ask for formally. But I can see, Jane, that there would be a way of initiating that. You could just ask the mediator, I suppose, if you could facilitate it.
Yeah, certainly. I mean, the Bristol mediation that I was involved in, we had video conferencing. I also had the mediator's telephone number, and we spoke on a few occasions throughout the day by telephone. So you can.
Yeah, and actually using different media, you could actually phone your opposite number if you wanted to, I suppose. And I suppose as long as everyone understood, and that maybe is the point, is we'd have to have it in the mediation agreement at the outset as to what the protocol was for that everyone can use anything they like, but that they must still be bound by the confidentiality, etc.
Absolutely.
Good. An interesting question actually has come up about using remote ADR of various sorts, but requiring either a sign language interpreter or a foreign language interpreter. We all know how difficult these are actually in court when everyone is there. The process is certainly quite slow, but do you foresee any particular issues? Maybe Ross first, in actually giving evidence, for example.
Yeah, no, I don't actually. So I'll actually point out the Seoul Protocol envisages a place for interpreters. I suspect it's envisaging foreign language interpreters rather than sign language interpreters, because obviously if you are taking part in international arbitration, language could be a key barrier. So there are provisions in the rules to allow for that and to allow them to be present when it's required. It will add an additional time delay for the interpretation to take place, but again, that's something that a lot of us are familiar with having done in court. It does add that bit of extra time, but it's by no means a barrier at all.
Yeah, I can see. I mean, it is a difficulty, but it's not a particular difficulty simply because you're acting remotely. Well, we have a couple of minutes left. There's just a few questions that are piling up here. One of them relates to the record function, which I think covers both positive and negative things. One question's come up saying, what if somebody is recording and you don't know? I think the answer I've had certainly from a mediator on that is that it's only the mediator who's allowed to record. And I think there is a technical way of doing that with Zoom. Is that your experience, guys?
Yeah, that's right, Joyce. The mediator has control over the Zoom settings for the meeting. So it would only be the mediator who would be allowed to, who would be technically able to record it, but they wouldn't do that as a matter of course. It wouldn't be recorded.
Sure. And actually, on a positive note, the record function could be used. Very helpful suggestion, actually, that someone's put forward is that, particularly in a mediation, and I suppose this could apply to certain aspects of an arbitration too, if you wanted to have it recorded as to what had been agreed, rather than having a
Yeah.
joint minute or something of that. Actually, having the mediator or the arbitrator record the settlement a deal, and
Yeah.
you know, for example, things like apologies or whatever, if it was in a mediation, that might actually be something that was quite helpful. What do you think?
Yeah, absolutely. It'd be good evidence of what had been agreed if the mediator was to read it out and both parties were watching and were to confirm that they agreed to those terms.
Yeah, absolutely. I mean, you would hope, and obviously the main aim would be to have it documented in a clear settlement agreement that was signed as soon as possible after the meeting. But you know, there are plenty of reported cases out there where solicitors' emails have been analysed. At what point was an agreement reached?
Yes,
You know, what
could
were
be
the
an interesting
terms?
one. Yeah,
You know, yeah. I mean, that would be a great piece of evidence to have if you were trying to enforce an agreement.
it would indeed. Well, I think we still have a few questions, but we will come back to others individually if we haven't managed to reach you so
Yeah.
far. But I'm conscious of time, and I know that people will have other things to do, even if it is from their own desks at home. So I would really like to thank everyone for participating, and those who asked questions particularly, because it's very useful to us to understand what the issues are, the concerns that you might have, so that we can look for solutions for them before they arise in mediations or arbitrations that we're actually involved in. We will, as I said at the beginning, follow up with you. We will send you a link to the recording, and we would be happy for you to pass it on to colleagues if you think they would find it helpful. But can I just say thank you very much to my colleagues, and thank you to all of you for attending, and do join us again for another webinar in due course.